forward now. I want to welcome you to the last class session. I have just a few things to say as we begin our last class session. The first is that I know that from feedback I get from some of you that this class may be experienced by some of you as being a little harder than other classes you may have taken in the program. If that's the case, I certainly hope as you reflect back on the class that you'll see the reasons that we did what we did and that we connected the dots in the ways that we connected them. I'll just say this straight up. I always say it in the last week of an ethics course. There's no reason ever to minimize the study of professional ethics. In fact, as you begin your careers, the greatest wisdom I can give each of you is to continue to be a student of professional ethics codes and laws throughout your careers. The reason is the AMFT Code of Ethics is revised from time to time. The KARs are constantly under revision. The KRSs, the Kentucky Revised Statutes, very rarely are revised because the legislature has to do it and they don't want to do, and there's good reason for trying to keep that from happening. But and then federal laws change from time to time. The HIPAA protocols have changed considerably since they were enacted. The HITECH Act came along as a new thing in 2009. So it's always changing. And I can tell you, this sounds harsh. Licensure boards don't take ignorance or lack of knowledge of the law and ethics as a reason, as a good reason for not complying with what the law said or what the AMFT Code of Ethics said. There's been a couple of times, and I'm not saying this would be anyone here, I'm just talking about things I've seen through the years that I had to shake my head at with adults that would take these stances and become angry. I can remember a number of years ago, someone was disciplined by an MFT licensure board in one of the states that I've lived in, and I was at the meeting, and the person was ranting, I shouldn't have to be held accountable for stuff that's so boring. But so boring. And somebody on the licensure board said to this person, well, didn't you take a class? And they said, yes, the class was mind-numbingly boring, so why am I being held accountable for it? And these things are. And the licensure board person just said, we made a mistake with your case. And the person said, what? Hopefully he said, we were lenient with you. So there should not be any leniency for the person. I think about someone else that I knew that was licensed and was disciplined when I was at Abilene Christian. We, in the summers, took all of our students who were in ethics class to a Texas Board of Examiners of Marriage and Family Therapists licensure board meeting. We took them to Austin to do that, and one of the reasons we did that was we required them to go to an Austin in Texas. It's a very open process when someone's disciplined. What happens is they have open hearings, and the person goes in. Texas is a big state, right? It's like a small country, so sometimes there's like 200 people in these meetings, usually not that many, but this time there's a bunch of people there. What happens in Texas is the professional investigators they have come up front. There's like 4 of them, and they investigate they investigate the complaints that are there, and then the complainant comes up, and the person who's defending themselves, and usually both were there. And I can remember one man coming up that had gone to a pretty good school in Texas. It wasn't ACU. It was another school. I was so thankful it wasn't ACU because I was there at the time, and he had not kept his license, in Texas it is a licensed marriage and family therapy associate here because it's an entry-level license. Here it's a permit, as you know, in Kentucky. In Kentucky it's a marriage and family therapy associate permit. In Texas it's a licensed marriage and family therapy associate because it is a license there. But he had not renewed it, and he had not done any continuing education. And his defense before the board was, no one ever told me that I needed to do this. And they brought up the syllabus from his course that the university had gone to and said, we saw this in your disposition, but we saw that it said in your course, in the syllabus we asked, that this was discussed this particular week, and we saw assignments linked to it. And the guy, and I said, is your syllabus not accurate? And the guy just without blinking said, no, I did those on autopilot because not everything you do in graduate school you have time to absorb. So it was like I didn't do it. A person who takes a stance like that deserves to be disciplined. I think we all agree, right? A person who takes a stance like that deserves to be disciplined. So what we've tried to do throughout the course is to give you the tools for making ethical decisions. We've kind of spoken about how to read law and ethics, things like if it says shall, you have to do it. If it says may, you have some wiggle room. We've talked about how in Kentucky, in the state of Kentucky, the KRSs and the KARs and the KRE that's relevant to us fit together. Hopefully you saw that. Hopefully you see how the AMFT code fits and how federal HIPAA law and high-tech law fit. We've tried to show you how all of that fits together and giving you the tools to keep up. I cannot overestimate how important it is for you to be in the habit of going to mft.ky.gov. Again, you put the HTTPS in front of it. I'm sorry, if you put the www in front of that, it doesn't work for whatever reason. But to go to mft.ky.gov, keep, from time to time, review the KRSs, review the KARs, and review the minutes of the meeting every month, particularly if once a month you make a habit of reviewing the minutes to see, the minutes from the previous month, and, you'll be able to keep abreast of what's important. That's on you, the licensee, and I have every confidence every one of you can do that. Also, as we begin, this is all preliminary stuff, so we're going to get some meat today. Don't just click off and say just rambling on about summarizing. I am summarizing, but that's before I get to the meat of the stuff. Also, I think you'll find when you take the AMFTRB national exam that these tests, the multiple choice questions you've done, will be surprisingly similar in structure and in scope to what you're going to find on the AMFTRB national exam. I've been asking you on the last few tests to justify your answer. Some of you, I've made some notes on about that when you didn't get it correctly because I could see some of the things you did. So part of that is to kind of get a sense of maybe if you have a way of answering questions sometimes that will get in your way on actual national exams. So hopefully everybody looks at the feedback that's sent and does something with that. Okay, so let's roll up our sleeves and get to today's topic. First, I want to talk about managing the complaint process and what you should do if a complaint is filed against you. So I'm going to share my screen here in a moment, and as I share my screen, you'll be able to, I believe, see the AAMFT Code of Ethics shortly, not just at first, because when I do this at first, you're not going to see that. You're going to see the syllabus. So I'm going to go here. I'm going to go AAMFT.org like we've done. And then I scroll over Enhanced Knowledge. Again, you scroll over that. And then you come down to Legal and Ethics You click on Legal and Ethics, and once you do that, you come to the Code of Ethics for Marriage and Family Therapists. But I'm not going to actually go there first. I want you to see something that's useful if you're an AMFT member. They have what they call legal and ethical consultations. These are for members of AMFT. Your membership in AMFT allows access to various member benefits, including consultations with AMFT's legal and ethics staff, member consultations. Members of the following AMFT member categories are eligible for legal consultations: pre-allied mental health professional members, allied mental health professionals, preclinical fellow, and clinical fellows. Legal consultations do not include interpretation of state law or local laws, so they don't interpret them for you. Assistance with viewing or drafting documents, they don't do that. Representation of members against third parties, they don't do that. Consultation or issues unrelated to members' professional practice of marriage and family therapy. As with any legal topic, members are also encouraged to consult with a local attorney, and we're going to talk to you about that. So for response time and contact information, the next time you're faced with a legal ethics question, consult with AMFT's legal and ethics staff before you act. Consultation is available through a few different means. One, ask your questions via email at ethics@amft.org. You can give a hypothetical. They really encourage you to give a hypothetical case. Hypothetically, schedule a phone consultation, and you can click on that to do that, or call the attorney directly at this third one. That's probably the hardest one to do because they only have 2 attorneys that are at AMFT, and only one of them pretty much does the consultations. It's Stephanie Frank. She's usually the AMFT attorney that's there now that does these. So I always recommend that you either do the email or schedule a phone consultation, and you see the times that they're available. And so it just tells you all the stuff you can do. Consultation resources for you to include your licensing board, a local attorney, and your professional liability insurance. Okay, so that is kind of an important thing for you to know about consultations. Now, I'm assuming everybody here has CPH insurance, because that's an important thing for you to have, is for your liability insurance. For that, they have consultations for members as well. Most of them do. Let me just go to policy holders here. They have consultation available as well. They have consultations available as well. So they say they give you 2 a year, but the truth is they'll give you more than that. The reason is they would rather consult with you and have you avoid something than to pay out the claim. It's cheaper for them to have their attorney talk to you, right, than to make a claim. But it's really something that's really, really important for you to know if you have that type of insurance. And I'm going to come back and talk about the type of insurance, that liability insurance you want as well moving forward. So that's one piece of this to look at. The other thing is this, and this is very, very strong. I'm going to put this on a sheet of paper here so that you can see it. I'm going to shout at you. And I know that that's rude to do, but I'm going to shout at you on paper. If a complaint is filed against you, here's where I shout in caps, it is imperative that you work with an administrative law attorney in your state to address this. And if an AMFT ethics complaint is ever filed against you, you want to work with a good one as well. Usually people, because I was on the AMFT ethics committee, and then after that the AMFT judicial committee, so I've got some experience with this stuff. Usually it's administrative law attorneys that handle these kinds of complaints. So it's imperative that you work with an administrative law attorney in your state to address this if a complaint is filed against you. I cannot emphasize that enough. That's the type of attorney that you want to work with. What many people do, regrettably, is if there's a problem with a complaint, is they go out and they get just any attorney, maybe a family friend attorney or someone that's well known. The people that are well known are generally not administrative law attorneys. They're people that do torts law, that sue people, or they do criminal law. Administrative law is a very different type of law, and there are people in the state that do administrative law. They're usually people that worked for a while or for a long time in state government in Frankfurt, and they know how administrative hearings work. Because what will happen is if a complaint is filed against you, you'll have to follow administrative law steps. So I'm going to come to the administrative regulations and look at this as well and what happens. You see here, you can see this. I'm just on the KARs, and I don't even remember the name of it, because all I do is I go here and then I look at the headings for the complaint procedure. That's what I need to know, is how to do a complaint. All right, so we have, as always, the complaint procedure and the KARs, and again, these can be changed by the licensure board in some ways. Definitions: chairman means the chairman or vice chairman of the board, the licensure board. Charge means a specific allegations contained in a formal complaint, as defined in the subsection of 5 section, issued by the board alleging a violation of the specific provisions of KRS 335 or 201 KR Chapter 22. Complaint means a written allegation of misconduct by a credentialed individual or other person that may constitute a violation of one of those chapters. Complaint screening committee means a committee consisting of 3 persons on the board appointed by the chairman of the board to review complaints, investigate reports, and to participate in informal proceedings to resolve a formal complaint. In addition to board members, the executive director of the board or another staff member must be appointed to serve on this committee. So here's what you should know. If a licensure board complaint is filed against you, looking at number 4, not every member of the board is going to know about the complaint. They divide the board members into the complaint screening committee and then a hearing committee. So the people that would be on the hearing committee, they don't know anything about this because they don't need to know about it until the end, and I'll talk about that in a moment. But the complaint screening committee, they look at these and say, do we want to file a formal complaint or not? Do we need to have an investigation or not? Most complaints go away. The majority of complaints go away. Talk to anyone that you ever talk to who's been on the licensure board or has been on the AMFT ethics committee, either one, and they'll say most complaints are bogus. People get mad. They don't understand. They come to you because they desperately want their marriage to work, even though their partner has moved in with another person and has decided that they want to spend the rest of their life with the other person. This person believes that marriage is forever after, and they think if you're any type of a therapist, you're going to bring the other person back and help that other person to relove them again. It doesn't always work that way. People likewise sometimes come to you because they care about their kids' grades and they think if you're a competent therapist, then their kids are going to get good grades. Sometimes that happens, sometimes it doesn't. The truth is what we do doesn't always work. The truth is that the boards or the AMFT doesn't expect it always to work. What they expect us to do is to work within agreed upon, agreed upon scope of practice, and to do things that are commonly agreed in the field to be the appropriate things to do. And after our assessment, if we assess well, we do our due diligence to assess well, and then we intervene well, and we continue to assess if it works, but sometimes it doesn't. All right, so number 5 here is important. Formal proceeding, a complaint rather, means a formal administrative pleading authorized by the board that charges a licensed individual or other person with an alleged violation and commences a formal disciplinary proceeding pursuant to Chapter 13B, request the court to take criminal or civil action. The truth of the matter, folks, is that the complaint that you usually get when you go to your mailbox and you get the certified mail from the board is not a formal complaint. It's the copy of the complaint that the person has filed against you. Usually a formal complaint comes after the screening committee decides whether there's a basis for that or not. It's kind of like how not exactly the same, but kind of like how a grand jury works, right? Grand juries listen and say, is there enough evidence here to pursue an indictment, yay or nay? Well, then the complaint screening committee kind of does that as well. And formal proceedings means the proceedings instituted at any stage of the disciplinary process with the intent of reaching a disposition of any matter without further recourse to formal disciplinary procedures under Chapter 13B. Would everybody listen carefully to this? Would you please listen very carefully? This could have ramifications on your career. You do not want to agree to an informal resolution of a complaint without consulting your attorney first, without fully understanding what that means. I know of a person now, I can't say any more about the situation because I'm involved in a way because I am helping the person, respond to what's happened. But I know of a person who had, who has recently agreed to sign an informal complaint, and that person probably should not have done this because if they fought it out, there would have not been enough evidence. You really want to look at this because that board attorney is going to act like he or she's on your side. Right now it's a he, sometimes it's a she. It just depends. They go through them quickly. The board attorneys are usually, but not always, people who are pretty quick, who are fresh out of law school, and they're what they call an assistant attorney general in the state of Kentucky. There's a ton of these folks. Most people who are assistant attorney generals are in 3 categories. 1, they're new and they're getting experience before they move on to something else. 2, they're people that have children or other obligations, and it's a little easier way of making a living than being in the private practice of law or being in a big law firm or corporate law, so they do that. And then thirdly, there's some people that just can't get other jobs, and so they stay there for a long, long time. And then fourthly, there's some people that just really like that kind of law, the kind of thing, and they stay there. I have known some people, well, I grew up in the state of West Virginia in the capital city of Charleston, and I knew a handful of attorneys there that were really, really competent that stayed in assistant attorney general type positions throughout their whole careers. Some of them did more supervisory stuff as it moved on because they didn't want the stress of doing something else. They paid pretty well, had good benefits, and their quality of life was more important to them than making money. But the point of the matter is they don't represent you. They represent the board. And they'll come alongside of you and kind of be your buddy and say, look, I'm trying to give you some friendly advice. Take this. It's better than getting a disciplinary action. Take this. It's better than losing your license, etc. And that probably is true, but only if you have a good attorney will you know whether it's worth fighting it or not, because most disciplinary actions don't end up in revocation of license. They have to have proof before they do anything. So don't let the person, the attorney who represents the board, who does not represent you, come alongside you and say, let's just settle this. You want representation, and you want a really good administrative law attorney representing you. Again, let me say that again. You want a really good administrative law attorney representing you if it comes to this. And then an investigator means an individual designated by the board to assist the board in the investigation of the complaint, or an investigator employed by the Attorney General of the board. All right, so here's, as we continue down in this is tedious, but I'd rather you have some knowledge of this before a complaint's filed against you than, looking at it really closely for the first time afterwards. I think I've mentioned this before. It's not to scare you all, but to kind of, help you to do your due diligence to be prepared. There's an organization that's called CLEAR that supports the regulatory boards for the regulated professions of the United States. Optometrists, dentists, physical therapists, marriage and family therapists, professional counselors, social workers, and on and on. So what? Licensed optometry dispensers or whatever they call them. There's all these regulated professions. CLEAR supports them, and this is really old data, so it probably isn't relevant now. But about in the 1990s, CLEAR did a study over a several-year period of all of their boards and professions, and they concluded that on average over a 30-year career, most regulated professionals are going to have 2 complaints brought against them. 2 complaints. Now, before you have a heart attack or have a panic attack or something, the rest of what they found was that the majority of those complaints are dismissed. Okay? So what it's saying is that it's likely you're going to have 1 or 2, 3, maybe more complaints against you. It's foolish to try to worry about avoiding complaints or avoiding lawsuits. You can't. Some people sue because that's what they do. Some people file complaints because that's the way they live their lives, usually for an advantage. The question is not, how can I avoid being sued or how can I avoid a licensure board complaint? The better question, or really the real question that you want to put energy in, is how do I know the laws and regulations, how do I interact with people, and how do I document what I do so that if someone files a complaint against me, it's likely dismissed, or if someone files a lawsuit against me, it's likely that they're not going to get any damages against me. That's the better question, right? Those are the better questions. So, and that's part of what I'm wanting to do with you today. So Section 2, receipt of a complaint. A complaint may be submitted by an individual, organization, or entity. So that happens a lot. Individuals sometimes, usually they're people, your clients' partners, or your clients' parents. They'll file a complaint. An organization could. I worked in the community mental health center in Cincinnati a number of years ago that terminated 2 social workers for good reason, for cause, and they thought what they had done was so egregious they filed complaints against them with the Ohio Board of Social Work and the Kentucky Board of Social Work and the Indiana Board of Social Work. You ask why? Because they were carrying licenses in all 3 states. They wanted to make sure that what they did was so egregious that my employer wanted to make sure that they wouldn't do this with other people. I'll tell you what they were doing. They, instead of writing up case notes, they had like little templates, and they were changing the names on them and putting them in for everybody so they weren't real records. They figured it out, and so they didn't really have records on people, and they were working with severely mentally ill clients, so it was even worse, you know. And so they were disciplined in all 3 states. One of them drives a truck today, and I don't know what the other guy does, but, you know, they never worked as social workers again. So that happens for entity. It shall be in writing using the complaint form and instructions. There's a complaint form on the MFT board site and signed by the person offering the complaint, and may be filed by the board based upon information in its possession, so the board can actually file it itself. Upon receipt of a complaint, a copy of the complaint shall be sent to the individual named in the complaint, along with a request for that individual's response to the complaint. So if someone files a complaint against you, you're going to get a copy of this document. The individual shall have a period of 20 days from the date of receipt to submit a written response. So the first thing you should do when you get a complaint is to read the blankety blank 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 thing through a couple times, gather your notes together, gather your thoughts, and then don't respond to the board. Before you respond to the board, you want to immediately call your insurance company. Hopefully it's CPH Insurance and another insurance company. I'm going to talk about the right type of insurance to get today. There's 2 types of liability insurance. We want to make sure you know the differences in them so that you can get the right kind. You have a period of 20 days from the date of receipt to submit a written response. So you let your attorney do that. You stay on board to make sure that that happens within the 20 days. And then upon receipt of the written response of the individual naming the complaint, a copy of the response shall be sent to the complainant. So they make a complaint against you. You respond within 20 days with your attorney. And again, you want an administrative law attorney. Let me say that again as forcefully and loudly as I can. A good administrative law attorney working with you. Usually a good liability insurance company will provide one for you, or you can, or oftentimes they'll let you get your own and they'll pay for it. Upon receipt of the written response, individual name, complaint, copy should be sent to the complainant. The complainant shall have 7 days to receive to submit a written reply to respond. So here's what happens. They file a complaint against you. You have 20 days to respond. You respond within the 20 days, and then the complainant has 7 days to respond, to give a rebuttal. Fair enough. What happens after that? Initial review, 1A, after the receipt of a complaint and the expiration of the period for the individual's response, the complaint screening committee shall consider the individual's response, complainant's reply to the board, and any other relevant materials available, and make a recommendation to the board. So that's what they do. They look at it. They make a recommendation. The board shall determine whether there is enough evidence to warrant a formal investigation of the complaint. Folks, let me say this again to hopefully deal with any anxiety you may have around this. The vast majority of complaints are dismissed at this time. Now, one of the assignments that you have this week is to make up 3, and we're going to talk about this before we end today. We're going to talk more about the assignment before we end today. I've been looking at my YouTube video statistics, and I've noticed none of these have gone less than an hour, and the average time that people looking at these are 20 minutes. So if people have already gotten off here, I guess they're not going to get, more directions. Want to get more directions on the SOAP notes and all. But that's important, because if you have good records, good SOAP notes and good treatment plans, generally those complaints are going to go away. So, but let's look what happens. If the board determines before formal investigation of complaints without merit, it shall dismiss the complaint and notify the complainant and respondent of the board's decision. If the board determines, so that happens, and 3, if the board determines, it's over with at that point. But keep in mind, that person can still try to sue you, so you really want to be in a period of review from the beginning of this, of your notes and your documentation with your administrative law attorney, because that person could still seek a remedy in the civil court. That usually goes poorly for them, but I think we know not all attorneys are ethical. Most of them are, many of them are, but some attorneys will, take any case for a fee. But it's really not that much generally to worry about. If the licensure board is screened and said it's not worth moving forward with, usually it doesn't usually go well for people in civil court, but sometimes it does. But that's why you're really wanting to work during this whole period with your attorney around it. If the board determines that the complaint warrants a formal investigation, if you do have to have a formal investigation, it shall authorize an investigation of the matter and order a report to be made to the complaint screening committee. So an investigation occurs, and I've known several people that have been investigated, and they've had the complaints dismissed after investigation. Because they're investigating you does not mean you're going to have any complaint filed. That you're going to have any disciplinary action. It's just that it just means that the board has determined that there's enough to warrant an investigation. So again, this is where good notes come into play. This is where good treatment plans come into play. I'm angry about something that happens here in Kentucky more than anywhere I've lived, and I'm going to name it. There are some old school hands here. Most of them are retired now, so it's not as problematic as it was. But when I lived and taught here before, there were a number of voices in the state that said you don't want to keep any notes at all, because if you keep notes, then they can get you. Folks, if you don't keep notes, it's a slam dunk they're going to get you. You have violated, by not keeping a medical record, you've violated the code there. If you have notes that nobody can discern what happened, you're probably going to be disciplined, because in essence you haven't defended yourself, or they're going to get the board's going to charge you with keeping inadequate records. You have to keep adequate records. The AMFT Code of Ethics demands it. If you're a covered HIPAA entity, it requires that there's a medical record that can be released to clients, and you also, it's just good business to do that. So your records should be such that somebody looking at them can tell what happened in session. If you want to know if you're writing good records or not, I've asked you to write according to the SOAP format. You've got Diane Gayhart's lecture on it I gave to you earlier this week. Somebody ought to be able to go to behind you and see what happened session to session based upon your notes. Here's how you know if your note's good enough or not. If you got hit by a truck, coming home from work, would the therapists that are assigned to your cases, would they be able to look at your notes to see if what you did was accurate? All right, let me come back to what I'm getting a far afield here because this all ties in together. It all ties in together. All right, so why is notes go into investigative report? Why did I put that there? Because the investigator will interview you. The investigator will interview the complainant, and one of the things that the investigator will look at, and likely the licensure board will have already looked at, is a copy of your case notes. You send a copy of your case notes to the board, a copy of your treatment plan to the board, and they look at this and they say, okay, did this person assess, diagnose, well, does this person, are all the informed consents there? Is everything there? All right, so B, then the board shall determine whether there's been a violation of KRS Chapter 335 or 201 Character 22, and a complaint shall be filed. If the board does not warrant issue, then 2, if the board determines that the complaint does not issue the formal complaint, it shall dismiss the complaint and know the board's decision. The board's decision. If the board determines that a violation has occurred, but is not serious, the board shall issue a written admonishment to the licensure. A copy of the written admonishment shall be placed in the permanent file of the licensee. B, the licensee shall have the right to file a response in writing to the admonishment within 30 days of the receipt and may have it placed in the permanent file. Alternatively, the licensee may file a request for a hearing with the board within 30 days of admonishment. Upon receipt of the request, the board shall set aside the written admonishment and set the matter for hearing pursuant to the provisions of KRS Chapter 13B. You don't have to necessarily take a written admonishment. You can ask for a hearing. If you do that at that point, then you're likely going to have greater, if they find you guilty, greater penalty. However, again, that's why you have administrative law attorneys. I've worked as a expert witness in licensure board proceedings, and I can tell you this from my work as an expert witness that I've seen people who've had these admonishments against them. There wasn't evidence, their lawyers fought it, and the admonishment went away. But again, you really want to rely on your attorney at that point. All right. Upon receipt of the request, the board shall set aside the written admonishment and set the matter to hearing pursuant to the provision of KRS Chapter 13B. If the board determines that the complaint warrants the issuance of a formal complaint against the respondent, remember I said the formal complaints were something we deal with later. We're just now kind of getting down to formal complaints. The complaint screening committee shall prepare a formal complaint that states clearly the charge or charges to be considered at the hearing. The formal complaint shall be reviewed by the board and, if approved, signed by the chairman and served with the individual as required by KRS Chapter 13B. The formal complaint shall be processed in accordance with KRS Chapter 13B. If the board determines that a person may be in violation of KRS 2501, it shall A, order the individual to cease and desist from further violations, B, forward information to the county attorney of the county of residence of the person allegedly violating this, and then C, initiate action in Franklin Circuit Court for injunction ruling to stop the violation. So all of those things can happen. But now let me show you the settlement by informal proceedings. And let me talk about all of this other stuff. You really want to think about the ramifications of having a disciplinary action against you on your career. Depending on the disciplinary action, you may not be allowed to be on insurance panels. Depending on the disciplinary action, the AAMFT might also discipline you and take away your membership and in some cases forbid you to have membership again. Both of those actions are harmful to your career because There's, employers do searches, right, in the future. Have you had any disciplinary action taken? You say no, and then they do their investigation as part of hiring you, and it turns up you've had, guess what? You're not going to be hired, right? So then the rest of your career, you probably will get jobs, but you're having to tell agencies what happened, and some of them will take a chance on you, some of them won't. And then, or some people then do fee-for-service private practices, which are hard to make a living at. So you really, really want to think about, how hard you're going to fight a disciplinary action. Because you don't want to lose your license, but, at the same time, you don't want to have, restricted options. Again, that's why you have lawyers. That's why you get a good administrative attorney. That's why you have professional liability insurance. Settlement by informal proceedings. The board, through counsel and the complaint screening committee, may at any time during the process enter into informal proceedings with individual who is the subject of the complaint for the purpose of appropriately dispensing with the matter. They'll want to do this with you almost every time. The reason is they have to pay the attorney's fees that prosecutes the case for them in the administrative hearing. There's other costs that come to the board for getting an administrative hearing room, etc. It costs them several $1,000s to do that. It's in their best economic interest to settle with you, and usually the settlement will require you to pay attorney fees, to pay the fees that they've already, incurred with the state attorney general's office, because the state attorney general office bills them for that. Believe me, they're going to want to do that, and they're going to tell you that it's not that big of a deal. But folks, if you go back to the mft.ky.gov site, if you notice, most of those did not happen after a hearing. It happened after an informal settlement. You give up your right to fight when you settle. And again, sometimes that's a good thing, sometimes that's a bad thing. In my opinion, way too many MFTs in the state of Kentucky have just panicked, and they've agreed to informal orders, and they haven't even consulted their insurance companies or an attorney or an administrative law attorney. I've shaken my head, and it'd be inappropriate for me to talk about them, but of a handful of decisions I've known that people have made that has hamstrung their career when they likely would have gotten out of the accusations had they fought with the evidence that they had. An agreed order or settlement reached through the process shall be approved by the board and signed by the individual who is the subject of the complaint and the chairman. The board may employ mediation as a method of resolving it informally. Okay. I want you to see Section 6, Notice and Service of Process. A notice required by KR Chapter 335 of this shall be issued, the notice, and then notification. The board shall make public its final order and a disciplinary action, with exception of a written admonishment issued pursuant, and an action of restraint or to join a violation. All right, so it's time for me to show you something here. I'm going to show you something that I hope that you don't think is inappropriate. I'm going to show you license number 1 in the state of Kentucky. Before I go here, you're going to see that the legacy number was 001. The state gave other numbers a couple of years ago, but they had a simpler coding. You see the legacy number? It was 0001. This person was the first, he's dead now, he was the first board chair. He thought he had an administrative law attorney. He thought that he had entered into an admonishment. He didn't. And he went through, had a disciplinary action, and that followed him through the rest of his career. He died in 2009. There was a Kentucky Association for Marriage and Family Therapy when it was in existence. Several times they fought this, trying to get this to be overturned because the board did not consider KRE 516. You all know KRE 516. You read it. The board didn't. Here's the story. The man had a client who, the man, Dr. Sohan, was called to jury duty. He did his civic duty. He went to jury duty. He had a client who, or an ex-client rather, who was being charged with something. Dr. Sohan said he couldn't be on this jury when they were doing jury selection because he knew the person. Said he couldn't say why, and the guy said, and the attorney said why, it's confidential, and he said, so we have to tell us why. He says, I can't in front of all these people, and the judge said, I'm ordering you to do it. Because John knew KRE 516, he knew that when the judge said you had to say, order it, that he had to say, so well, this person is an ex-client of mine. The ex-client was found guilty, went to jail for 30 days, got out, filed a complaint against John saying that prejudiced the jury pool, the potential jurors are there against him and such. And so the board found him guilty. They didn't consider KRE 516. To this day, well, he's dead now, but until 2009 when he died, John would admit, and he would tell people publicly, he did trainings around this, that he made a mistake because he thought that he was just dispensing of this, that it would never be listed as a disciplinary action. It was further, he should have fought harder. Had he fought harder, because of KRE 516, he would have never been disciplined, right? For something like that, KRE 516. He would have never been disciplined. But because he cited an agreed order, it could not be undone. And we tried to get this done posthumously as well. So, cautionary tale about doing this. All right, so I'm going to come see if there's anything in chat. I hope not. All right, so I'm sorry. So, who pays for the administrative law attorney when you have to get one? Well, that's a good one, Jenny. That's a really good question. If you have a good insurance carrier, they will pay for it. If you don't have a good insurance carrier, then you pay for it. Okay. Jenny also asked, when you send a copy of the case notes and treatment plan to the board, does the client fill out a release of information form? Is there already one on file? Do you have that client come in and fill out a form? How does that work? Nope. The way it works is that if you look at what the law says, is that one of the ways that confidentiality is waived is if you're having to defend yourself. When you defend yourself in the proceedings, you can use the notes, you can use any of it. You're not violating your confidentiality, their confidentiality, when you use their material in a complaint. In fact, one of the things they're told on that form is that they understand that the case notes and what happened, they're in essence, they're knowing that what they talked about with you is going to be, kind of made public that way, somewhat public before they do it. So, yeah, that's part of it. Someone asked, have you ever been investigated? What was the process like? Yes, I was. I had a accusation made against me. I was investigated, and it was dismissed with prejudice, which means, I don't know if you know what a dismissal with prejudice means. It's the strongest it's the strongest dismissal you can get. And basically, saying the other person was lying and the court is so prejudiced against, well, heck, let's just look at it. I'll show you what it means. It's what you hope for if someone files a complaint against you. A dismissal of prejudice is a dismissal of a case on merits after adjudication. The plaintiff is barred from bringing an action on the same claim Dismissal with prejudice is a final judgment, and the case becomes how you say that word on the claims that were or could have been brought to it. So it's what you really want to see happen. You want it to be dismissed with prejudice. In my case, the person kind of contradicted themselves. The best witness I had was the person who made the complaint. I won't go into any more details than that. Okay. All right. So coming back, I'm sorry I didn't see all of these. Is there common complaints? Yeah, the most common complaints occur in custody evaluations and court testimony. People that do custody evaluations expect to get several complaints a year. They know what they're doing. They're usually dismissed. Is there clubs and newsletters that helps you keep up with all the requirements? Sometimes I don't know what the Kentucky Interest Network is somewhat new, so they don't do as much as they'll probably do more in the future, but it'd probably be in everybody's interest to join the Kentucky Interest Network. Michelle Oak is really involved with that. If you want more information about that, that's really a good question. All righty, so those are all the questions that you had. All right, so let me come now here at the end to discuss with you momentarily the assignment that you have due related to SOAP notes and the treatment plan. So I've given you. Okay, I'll come back to those after I discuss this, Jenny. Just put these. If you could just paste them again. Say here are the ones that I missed. Just paste those down there, and I'll get to them. I want to make sure I answer all your questions. All right. So for this, I sent you links, and they were really good links. Diane Gayhart's material is really good. You'll want to listen to all of it. It'll teach you how to write notes. But I'm asking you to write the SOAP notes because they're the most common type of notes. And if your agency is not asking you to write another type of note, then the SOAP note is what you probably want to write because it's the best type of note. Secondly, I gave you the information on the treatment plans. I'm asking you to learn how to do symptom-based treatment plans rather than theory-based treatment plans because agencies require those, and both of those are things that can help you, with your risk management. Believe it or not, the biggest risk management pieces that you have are having doing SOAP notes or the notes or the format that your agency requires alternatively that are complete enough that someone can follow what happened session to session, that also documents phone calls, etc., that were made in between sessions. You really, really want to write good notes. And if you have a supervisor that tells you not to write good notes, ignore them. They're setting you and themselves up for trouble. You have to write good notes. You're risk-proofing your practice when you write good notes and good treatment plans. So, now I gave you a video to listen to. You'll have to make up the particulars. In some ways, you're imagining what would happen in those sessions. I'm not, looking at, how realistic your sessions are. I'm looking at how well you can demonstrate you can do a subjective, objective assessment and plan part of a note. If you have not had me in MFT 516, you'll get me in MFT 516, and we'll do more there. All right, so let me look at what's been asked. So is the complaint procedure for those making complaints and for us to know what happens next if a complaint is made. how do clients know how to make a complaint? How do they know the process? Well, the process, that's all on, there's a complaint file, there's a complaint form on the website, so that's how they kind of know about it. In some states, Kentucky doesn't require this. Some states, like when I lived in Texas, they actually required you to tell clients how to make the complaints and point you in that direction. But Kentucky doesn't do that. Kentucky just has the procedures on the website. That's a good question. All right, so for the SOAP note, do you want us only to write our responses for SOMP, or do you want us to include all the information KR talks about on the YouTube video? Just the SOAMP. Just the SOMP. Okay. All right. Can you detail what you were talking about on session 1A, couple before? I'm not talking. I don't know what you're talking. I'm sorry. Sherry, are you talking about on session 1? Are you talking about our very first week together? The SOAP note assignment. Okay. Yeah. All right. So Sherry, if you look at that, you listen to this. You have to listen to the song and see what the song is about. There's a song called Independence Day there. It's about domestic violence and which a couple fight, and then their daughter comes home from an Independence Day parade. She finds the house burned down, and in finding the house burned down, what she finds when she finds the house burned down, what she finds is that her mom and dad were killed on it. So what you're doing is imagining this couple would have come to therapy before their tragic ending. I think if you look at the video, that will somewhat make sense to you. Okay? Okay. All right. So then let me come back. Okay. Okay. Yeah, it was a video. Yeah, it's in the video. Okay. Got it. Okay. Okay, great. Yeah, it's in the video. You'll be able to the video kind of tell the story. All right. So on the assignment it says okay. Let me look at the other thing that is kind of said here with this. So if there's a complaint, does that mean we will have a board-appointed attorney and an administrative law attorney in Kentucky or the state we live in? Hey, look, the board does not appoint an attorney for you. The board doesn't. The attorney may call himself a board-appointed attorney. The attorney for the board represents the board. They'll be representing the board's interest, and it's up to you whether you get an attorney or not. The board, and never ever the attorney working for the board works for the board. That person represents the board's interest, not your interest. It's up to you. You don't have to have an attorney, but it's up to you to get one if you want one. And I always recommend that you get one, and usually your insurance company will take care of it. Please don't think the board is going to appoint an attorney for you. A lot of people think that. I know it sounds strong, but a lot of people have thought that because of the way the board attorney comes alongside them and says, I'm the attorney for the board, I'm here to help you. No, what they're there to do is to dispense of the case, to get you to sign an agreed order so that they can win the case for the board with little as possible. So you absolutely want to carry liability insurance, and you want to get your own attorney. Man, that is such a great question. I'm so glad you asked that question, because too many people have assumed that attorney that the board has that contacts you is representing you. No, they represent the board. They don't represent you. They're working to have you to do an agreed order so that you can be found guilty. That's just the truth of it. Okay, so the final thing I want to work with you on is the type of liability insurance that you want to get. I want you to see there's two types of insurance. One is called claims-made insurance. One is called occurrence insurance, and I will deal with this very shortly here as soon as I pull up the article that I need to do. Okay, handbook. Where is the handbook? Okay, got it here. Need to get to it. Okay, I'm giving you a link here that I hope that you'll always keep. In fact, when this goes away, as you know, as soon as I finish lecturing today, the links go away. So you want to click on this link in chat and keep this and look at it. So the difference between occurrence policies and claims-made policies. I am going to strongly encourage you to have an occurrence policy throughout your careers. Never, ever opt for the less expensive claims-made policy, and I will tell you why here in a second. It's fool's gold. First of all, our liability insurance is not that high as MFTs. It's not that high at all, and getting an occurrence policy makes all the difference in the world. You definitely always want an occurrence policy. Let me explain. It's 2019. Today is April 28th, 2019. Let's say tomorrow I decide I don't want to be a therapist tomorrow anymore. I'm going to be a truck driver. So I decide to drive a truck. I decide to give this up. So you were my client last week, and in 5 years you decide that I damaged you in some ways. You've had bad 5 years because of the therapy you did with me. If you file a complaint against me or a lawsuit against me in 5 years, if I had an occurrence policy, then all I would have to do in 5 years would be to say, hey, I was a marriage and family therapist in 2019. I was insured with you. Here is the policy number. They'll go back and look at it. If I have an occurrence policy, and they'll say, yes, you were. We'll defend you in your lawsuit. We'll give you money for your defense law. We'll cover you there. Rather, I meant to say, and we'll provide an attorney to defend you and help you with your complaint procedure. On the other hand, if I save $30 or $40 a year to have an occurrence policy, then here's what's going to happen. Is that they're going to say, okay, are you still insured with us? And I'll say no, and they'll say, sorry, if you're not insured with us, then we can't do anything for you. You're on your own. You see the issue there? Claims-made policies are only in effect as long as you're covered by them. I've seen some weird things in my career. I've seen children who have grown up and they've said, well, I saw this years ago in a thing. A kid grew up and developed probably schizophrenia, and when the kid was 50 said that a young therapist when they were in school had been involved in ritual satanic abuse. It was the therapist, the Catholic priest, the police chief, and the fire chief, and the mayor, they had all been involved in satanic ritual abuse. Person was pretty schizophrenic, but that's the reality of what happened when they were kids. So the therapist that was being charged was retired, and she was like 80-something years old. But because she had an occurrence policy, you know, they went back and they covered it. And she had a claims-made policy, they wouldn't. Yeah, is this insurance the same as what we get as the student? Absolutely. The AAMFT, the ACA, the APA, the NASW, the Pastoral Counseling Association, all of them will only give occurrence policies. If you get your insurance through your professional association, it's always occurrence. Yeah, so you can always get it through AMFT if you're a member. That is how you always want to carry your own insurance, and you should always carry your occurrence insurance that way. Agencies aren't always smart about this stuff. I do co-empty site visits, and we look at the insurance that they have. And recently, I saw someone that had a school that had claims made, and we all just shook our head because it was throwing everybody under the bus because they didn't know. All right, folks, I'm going to put a bookmark here. It's been great working with you all this term. You have until Saturday night at 11:59 p.m. to get everything in. Hey, and if you haven't filled out your evaluation, remember, after you complete your evaluation, take a picture or save the last page as a PDF. That doesn't let me know how you answered. It just has the thank you page on it or an advertisement. I know what they look like, and I'll give you the 15 points. Jenny, thank you. You've been a great student. Have all of you all. Take care. Hope to see some of you in 516 down the road. Bye now.